Stoicism, the Hellenistic philosophical school founded in Athens by Zeno of Citium in the early 3rd century BCE, profoundly shaped Roman intellectual and ethical life, including the realm of law and justice. Unlike other philosophical schools that emphasize metaphysics or rhetoric, Stoicism centered on ethics, virtue, and the alignment of human life with reason and nature. Its influence on Roman justice was both conceptual and practical, contributing to the development of legal norms, the ethical framework of judges and magistrates, and the integration of universal principles into Roman law. Historical context: Stoicism and Rome. Stoicism arrived in Rome during the late Republic, largely through the works of Greek philosophers such as Palladius and Posidonius, who tailored Stoic thought for the Roman elite. Unlike classical Greek society, which valued city-state citizenship and civic identity, Romans were increasingly involved in the administration of a vast empire, dealing with diverse peoples and legal systems. Stoicism's emphasis on universal reason, logos, and natural law, jus naturale, resonated with Roman jurists seeking a coherent moral foundation for laws that applied to all people, regardless of social status or origin. By the 1st century BCE, Stoicism had become deeply influential among Roman statesmen, lawyers, and thinkers. Figures like Cicero, Seneca, Musonius Rufus, and later Marcus Aurelius integrated Stoic ethics into their political and judicial reasoning. Cicero, for instance, explicitly connected Stoic ideas of justice with Roman law, arguing that the true purpose of law was to serve reason and the common good, rather than merely enforce the will of the powerful. Stoic principles relevant to justice. Several core Stoic concepts informed Roman legal thought. 1. Natural law, jus naturale. Stoics believed that certain principles of justice are universal, derived from human nature, and accessible through reason. This idea influenced Roman jurists to distinguish between positive law, laws enacted by humans, and natural law, which transcended local customs. For example, Ulpian, a prominent jurist in the early 3rd century CE, emphasized that human laws should conform to the principles of natural justice, a notion derived directly from Stoic thought. 2. Equality. Before the law, Stoicism posited that all humans share reason, and therefore all are morally equal. In legal practice, this translated into the recognition that justice should be impartial, offering protection to individuals regardless of social rank, gender, or citizenship status. While Rome maintained hierarchical structures, Stoic influence encouraged broader applications of fairness, such as the gradual recognition of some legal protections for non-citizens and slaves in specific contexts. 3. Virtue and duty. Duties of magistrates and judges. The Stoic ideal of virtue, wisdom, courage, justice, and temperance, provided an ethical framework for magistrates and jurists. Roman legal authorities were expected to act not out of self-interest or political gain, but out of duty to justice and reason. Marcus Aurelius, both emperor and Stoic philosopher, often emphasized the moral responsibility of rulers and magistrates to govern according to reason, embodying the Stoic notion that power carries moral obligation. 4. Rationality and objectivity. Stoicism stressed that emotions should not cloud judgment. Instead, reason should guide decisions. This principle influenced Roman legal reasoning, particularly in civil and criminal adjudication, encouraging judges and advocates to prioritize evidence, logical argumentation, and equitable solutions over rhetorical flourish or passion. Practical impact on Roman legal institutions. The integration of Stoic philosophy into Roman law was neither uniform nor total, but its impact is visible in multiple aspects of Roman justice. 1. Legal interpretation and jurisprudence. Roman jurists frequently invoked Stoic ideas when interpreting laws. For instance, the Institutes of Gaius and the writings of Ulpian and Papinian show recurring appeals to justice grounded in reason and universal principles. The Stoic notion of natural law served as a benchmark against which positive laws could be evaluated, guiding the development of doctrines concerning contracts, torts, and family law. 2. Equity, equitas. A key feature of Roman law was the concept of equitas, or equity, which allowed magistrates to mitigate the rigid application of statutes in pursuit of fairness. Stoicism's emphasis on rational and universal justice directly reinforced this principle, legitimizing discretionary interventions when strict legal rules produced unjust outcomes. A magistrate guided by Stoic ethics might temper penalties, adjust contractual obligations, or extend protection to vulnerable parties in line with reason and moral principle. Criminal justice. Stoic thought influenced attitudes toward punishment and rehabilitation. While Roman criminal law retained harsh measures, including execution and exile, Stoicism encouraged proportionality and the moral evaluation of intent. Cicero and later thinkers suggested that the law should aim not merely at retribution, but at correction and moral improvement, reflecting Stoic ideals of virtue and the rational improvement of the soul. 4. Slavery and legal status. Stoic philosophy promoted a universal moral community, which indirectly influenced debates about the treatment of slaves. Although Rome never abolished slavery, Stoic principles fostered humane treatment and recognition of certain rights, such as legal recourse for slaves under abusive masters, the ability to buy freedom, and the acknowledgement of personhood in specific legal contexts. Stoicism in the late Empire and Justinianic law. By the time of the late Empire and Justinian, Stoic principles had been fully assimilated into Roman legal thought. Justinian's institutes and novellae reflect an enduring commitment to natural law and ethical governance, emphasizing the moral duties of magistrates and the rational foundations of law. The Stoic heritage can be seen in legal precepts promoting fairness, the common good, and moral accountability. Even in codified statutes such as those concerning property rights, contracts, and inheritance, the imprint of Stoic rationalism and ethical universality is evident. Long-term influence. Stoicism's integration into Roman justice did not end with the fall of the Western Empire. Its principles were transmitted through the Corpus Juris Civilis to medieval canon law and later European legal traditions. Natural law theory, as developed by thinkers like Thomas Aquinas, directly drew from the Stoic Roman synthesis, linking morality, reason, and legal obligation. The Roman jurist philosopher tradition, infused with Stoicism, thus laid the foundation for a Western conception of justice as rational, ethical, and universally applicable, a conception still influential in modern legal philosophy. Conclusion. Stoicism profoundly influenced Roman justice by providing a philosophical framework grounded in reason, virtue, and universal principles. Its emphasis on natural law, equality before the law, rationality, and moral duty shaped the development of Roman jurisprudence, informed the discretionary practices of magistrates, and encouraged equitable and ethical legal decision-making. Figures such as Cicero, Seneca, and Marcus Aurelius exemplified the integration of Stoic ethics into public and legal life, promoting justice as both a moral and civic imperative. The Stoic legacy persisted through the codification of Roman law under Justinian and influenced medieval and modern legal thought, cementing its role as a cornerstone of Western jurisprudential tradition. Ultimately, Stoicism helped transform Roman justice from a rigid hierarchical system into one more attentive to ethical universality, reasoned judgment, and the moral responsibilities of those entrusted with legal authority. Sources 1. Long, A.A. 2006, Stoic Studies, Cambridge University Press. 2. Cicero, M.T., 1961, De Legibus and De Officiis, Cambridge, M.A., Harvard University Press. 3. Seneca, L.A., 2007, Letters from a Stoic, Penguin Classics. 4. Graham, 1997, Roman Law and the Legal World of the Romans, Johns Hopkins University Press. 5. Moss J., 2017, The Stoic Roots of Roman Law, Oxford University Press. 6. Ulla S., 2010, Natural Law and Stoicism in Roman Jurisprudence, Brill Academic Publishers. 7. Fryer B.W. and McGinn T.A. 2004, A Casebook on Roman Family Law, Oxford University Press. 8. Harries J., 1999, Law and Justice in the Roman World, Routledge.